All right. Good morning, everybody. Thank you for joining us. So why are we all here this morning? That's a good question. If you're like me, you keep hearing the spooky acronym getting thrown around. That's supposed to have huge implications come 2020, the CCPA. So California has enacted new legislation around consumer data, and unfortunately, this is going to change the way many of us conduct business moving forward. The purpose of this webinar is to familiarize ourselves with what the CCPA actually is, its effects, and how we need to adapt to make sure we're compliant and not subject to fines. My name is Chase Simmons. I'm a disaster recovery expert here at Quorum. I've worked with nearly 100 companies to strategize and implement data protection infrastructures, and I'm also joined by Mike Harrigan. He's a California-based attorney that specializes in data privacy laws. So here's what we're going to cover this morning. What is the CCPA? What are the risks of non-compliance? Does the CCPA actually apply to you? We're going to discuss the 12-month look-back provision, compliance complications for backup and recovery solutions, and then at the very end, we're going to have a little bit of time to answer any questions that you may have. And if you have a question in the middle of the presentation, feel free to use the question box in the GoToMeeting control panel. What I'll do is aggregate all the questions there, and then at the very end, we'll answer those in due time. So without further ado, I'll go ahead and let Mike take the driver's seat and get the show on the road.
All right. Thank you, Chase. I appreciate the introduction. It's great to be speaking with all of you today. My name is Michael Harrigan, and I am a data privacy and security attorney. I regularly advise multinational enterprises on global privacy and data security, particularly on the EU General Data Protection Regulation, or GDPR, and also the California Consumer Privacy Act, which is widely known around here as the CCPA. The International Association of Privacy Professionals estimates that over 500,000 companies in the U.S. alone are subject to the CCPA, purely from having revenues greater than $25 million. And in California alone, they estimate over 111,000 companies meet this criteria for having over $25 million. So the CCPA is a regulation that is impacting a massive part of the U.S., including California, which is densely filled with corporations subject to this regulation. And that statistic's not taking into account the corporations around the world that are also subject. So if you've been following data privacy and security at all, you've probably already heard about California's new law and the CCPA. The CCPA is the largest and most comprehensive privacy and data security law in the country, and it's set to go into effect January 1st, 2020. So what is this law, and what are kind of the main bouts about it? This law, first, it empowers consumers to learn what private information of theirs is in the possession of third parties, and it further empowers them to control the dissemination of that information. Second, the CCPA forces businesses ultimately to create systems to track this information, keep it confidential, and honor consumers' rights. And third, the CCPA imposes severe fines on companies that do not clean up their act once they are alerted to a problem. So why is it important that we talk about the CCPA today when it doesn't come into effect until January 1st, 2020? Well, it's important to talk about this regulation because there's things that in this law that require companies to begin tracking their California data today in order to be in compliance by January 1st. So let's talk about what are some of the consequences of potentially not complying with this regulation. And part of the hype around this law is its new penalties that it imposes upon companies in California. The CCPA creates potentially enormous liability in a space presently where liability is rather limited, but the act gives the California Attorney General the power to bring civil actions against companies for up to $7,500 per violation per consumer that fail to cure any violations within 30 days after being notified by a consumer that they are not in compliance. In addition, the CCPA allows for private plaintiffs, or in other words, consumers, to institute a civil action for unauthorized access, theft, or disclosure of non-encrypted or non-redacted personal information, which is due to the business failing to implement reasonable security measures. So, in essence, part of the takeaway is the ability to cure a claimed violation shortly after receiving a notice will be critical in mitigating liability under the CCPA. Practically speaking, this means that businesses need to implement incident response policies and put teams into place in order to respond if there's been a breach or there's been some sort of data leak. In general, we think an incident response plan should have 3 goals. First, the data allegedly exposed must be identified. So your company must properly assess the potential risks of what type of data was exposed. Second, if the data was exposed, where and to what extent that data was disseminated should be determined. And third, the remediation should begin as quickly as possible. Again, there's only 30 days in order, once your company has been notified of a breach or a non-compliance aspect, you have 30 days to cure this. And so, practically speaking, your company wants to put in place those incident response policies and have a team within your corporation to be trained and able to respond and remedy the situation in order to avoid receiving a bunch of these penalties. And I want to talk on a point in terms of enforcement. There's discussions going around where people possibly read where it might appear that it might not be enforced until 6 months after January 1st and 6 months after the regulation has gone into effect. And so the talk around this point is the Attorney General can begin enforcing the CCPA either 6 months after the regulation or any time before that when he's determined the final amendments and regulations are completely done. So it could occur as early as January 1st or 6 months after. But what many companies and consumers and everyone are overlooking, although the Attorney General's enforcement may be partially delayed, it doesn't stop the fact that private consumers can bring an action civilly against a company that's not in compliance on January 1st. So those actions are something that can hit the companies or any company right out the gates from January 1st, and that does not require the Attorney General to be enforcing the regulation. So let's put this in perspective a little bit. To put the CCPA's fines in perspective, a violation impacting 10,000 California consumers could carry a penalty of $25 million for an unintentional violation and as much as $75 million for an intentional one. And to further illustrate this point, if we look at a case most people are familiar with, back a few years back with Facebook, the severity of the CCPA's penalties considered with the Facebook Cambridge Analytica scandal, Facebook would have received a fine of $184.7 billion had that been today or January 1st under the CCPA. So that kind of puts some context on how serious California is with respect to enforcing its fines. And I think for consumers and alike and corporations that live in California, I think we can relate to California's interest in enforcing laws. If anyone's, for example, tried to buy a car in California that hasn't passed smog, I think that you can fairly say that California will enforce its laws in terms of making sure that all the regulations are played out and California gets its money especially. All right, so one of the big questions here is what businesses are covered under the CCPA and is your business covered? Well, the CCPA applies to for-profit businesses that do business in California and meet one of these 3 categories. The first being, if your company has an annual gross revenue in excess of $25 million, or your company annually buys, sells, receives, or shares for a commercial purpose personal information of 50,000 or more consumers, households, or devices, or your company derives 50% or more of its annual revenues from selling consumers' personal information. Now, the second category involving the buying, receiving, selling, or sharing the personal information of more than 50,000 consumers is likely to capture almost any company that conducts business online or through an app. Take, for example, a company that runs a blog that only has 150 visitors per day, for example. Over the course of the year, that 150 per day will add up to much more than 50,000. So, and if you're collecting personal information from those consumers, you land right in the scope of the CCPA. Further, under the CCPA, it has broadened the definition of what personal information is to capture information such as IP addresses, browsing history, information regarding a consumer's interaction with the internet, website, application, etc. Now, keep in mind, any company that has a website and all those attributes uses cookies and different tracking devices, which captures IPs and all that, etc. So the 50,000 number can rack up extraordinarily quick. And so companies need to be cognizant of how quickly that they can meet the CCPA's scope and fall subject to this law. Now, the CCPA got most of its motivation from the EU's GDPR. And one of the things like the GDPR has is that regardless of if your company is physically in California or located anywhere outside California, this regulation applies equally to you as long as you are doing business in the state and meet one of the 3 threshold requirements in the previous slide. So again, if you're a business, for example, in New York and you're doing business in California, you're going to be subject to the CCPA if you meet one of those threshold requirements. And considering California is the 5th largest economy in the world, and that's considering if it was its own country, in fact, companies around the world are going to have to comply with the CCPA because it's such an integral market for most businesses. Now, part of the reason it's so important that the compliance efforts truly should have started even last year is the fact that there's a 12-month look-back provision within the regulation itself that requires businesses to respond to consumer requests for personal information collected or sold within the past 12 months preceding the consumer's verifiable request. Now, let's take an example. For example, if on January 1st, 2020, one of your consumers were to make a request to know which personal data that you hold on them, you must look to your data processing and collection activities for the past 12 months beginning on January 1st, 2019. So what actions then must companies take to prepare to respond to consumer requests? So companies, in terms of being able to respond to a consumer request, need to start now data mapping and collecting an inventory of their information. So you need to track the data streams and create an inventory of what type of data that you have. So you need to learn, for example, when and how your business collects the personal information, where, for how long, on what systems your business stores the personal information, with whom your business shares the personal information. You know, although the CCPA does not explicitly state that you must engage in data mapping per se, it's implicitly required, because otherwise, how do you delete personal information if you don't know where the information even is? Thus, a lot of the work that you're actually going to have to do to allow consumers to be able to respond to different requests is going to be around creating an operational setting that allows you to have employees that are trained and being able to respond. So I like to think of this as like an iceberg. Yes, you're going to have to train employees. Yes, you're going to have a presence on the front end. But the underneath the iceberg is where really a lot of this action happens. You need to know where that data is. You need to understand how you're going to propagate a deletion signal through multiple systems, including now to third parties that you may have shared it with. So when we talked a little bit about what kind of things that you need to be able to do to comply with these rights for consumers, you need to think about actually all the steps leading up to what they're going to allow you to be able to do in terms of how you're going to actually comply internally to respond to a request. Your company must develop, for example, processes and procedures to authenticate and respond to a verifiable consumer request. There needs to be methods to understand the person that's inquiring about that request, what internal operation within the company currently is going to be able to say, how is this consumer in fact this consumer? How do we verify that? There needs to be a system in place to be able to do that. And the CCPA requires that the business offer at least 2 methods through which consumers can make requests to exercise their rights, including you need to have a toll-free number on your site. And if you maintain the website, you need to have different policies in place and mechanisms to allow the consumer to be able to make that request, which requires working with your website team and the whole team throughout your company in order to facilitate this situation. Now, compliance with the CCPA, many people are wondering kind of timeframes and different aspects of, should we start today or should we start tomorrow? How long is it going to take, etc. The reality is with the CCPA, it requires a cultural shift within your company. This is not something that we're going to work through and just say we're in compliance today and nothing happens. In order to effectuate and actually comply, you need to have cross-functional communication within your organization, such as your HR team needs to understand what type of data they're handling, your marketing team. You need to identify who in your organization, for example, is going to be the stakeholder responsible for responding to the request. Should it be a team of individuals? Should it be a person, depending on the size and scale of your organization? And you need to start tracking your data flows, not only internally, but because the CCPA requires that you understand where your data flows with your third parties. So for example, any third-party vendors, or it could be your accounting firm, any external vendor that which your company works with, your company needs to go through and reevaluate that vendor contract that is in place and understand, can this vendor go out there and sell your data after you've shared it with them? How are they handling your data? What security measures are they taking care of? So there needs to be redrafting and policies in place to understand not only where your data is at internally, but how your data is traveling externally to your vendors. What are they doing with your data in order to keep track and be able to respond to the consumer's request and disclose to them how, in fact, you're using their data? Because transparency is at the front of this regulation, where consumers, CCPA doesn't want to tell you that you can't use data anymore for selling it, for example, but what they do want to tell you is they want to make sure that consumers are aware of what you're selling and how you're using it. That is, so they are putting a major burden there. So you are able to still facilitate some of the things that you want to be able to do, but the consumers need to understand that you are in fact doing those things. And so the consumer rights are extraordinarily important, and you have to you got to create a functional framework within in order to work within the new CCPA requirements. Now, so beyond the new processes and procedures, I'm going to hand it over to Chase, and because one of the other facets about this, which is so important and where Quorum can be instrumental in helping your business in addition, is the security behind protecting your data and actually inventorying and storing it in the proper setting. So without further ado, so let Chase kind of take it off from there.
Awesome. Thank you, Mike. So as Mike discussed, consumers will have the right to inquire about data organizations hold on them. If you receive one of these requests, you typically have to respond within 45 days. So what happens if this data is no longer on your production server? Well, you still have to respond to this request, so you'll most likely have to leverage your backups to adhere to that request. It's pretty important that you have a reliable backup and recovery solution that self-tests itself, so you know that it works when you need it to and allows you to easily search for specific data sets. Security, probably one of the most important pillars. Is your data protected from threats? So as Mike said, any hack or breach must be reported, and both your production and backups are subject to this. The CCPA extends the current landscape for data breach liability under California law. It permits a private right of action for unauthorized access, theft, or disclosure of non-encrypted or non-redacted personal information due to the business failing to implement reasonable security practices and procedures appropriate for the particular type of personal information. So how Quorum addresses this is Quorum always encrypts your data in motion and at rest to ensure the highest security measures. The solution hosts itself on a separate network from your production. So for example, in the event that a bad actor gets into your production network and starts fishing around, they won't be able to find and lock down your backups with ransomware, since they won't be able to find your backups on that network. Really important, as Mike discussed, segmenting your data and knowing where it is. It's important to separate church and state to make sure that, if someone does get in or if there is a breach, that at least it's contained on the forefront. And then the final topic I want to cover is the right to be forgotten. So consumers now have the right to be forgotten. And what this means is if you receive one of these requests, you have 45 days to remove the consumer's data from your databases. So that's great. We can delete it off our production servers. Awesome. Continue on. Well, what about the consumer's historical data that still exists on your backups? You must remove their data from your backups as well. It's all covered. The CCPA discourages the unnecessary stockpiling of data by requiring companies to dispose of data that has outlived its intended purpose. This is why data must have a definitive life cycle. Holding data forever is no longer a viable solution, and Quorum is addressing this issue by flagging forgotten data in your backups, notifying you, hey, if you restore from this instance, there's consumer data sets that must be deleted beforehand. So just to kind of recap the points that I discussed. Service availability. Instant backup provides an efficient workflow for adhering to the 45-day response timeline. Quorum conducts self-tests to ensure backups are successful and available when needed. Very important. Indexable and searchable. So Mike discussed, okay, you might have a consumer's data on hand, but do you know that that data actually lies? So Quorum offers great visibility into your consumer data that you possess, and it's vital when fulfilling a consumer request. Security. Data is fully encrypted in motion and at rest. As I mentioned, it's hosted on a separate network. So if there was any penetration into your production servers, you know that your backups are safe. And then finally, forgotten data. Better track the full lifestyle of data, and system flags consumer data that must be removed. Going into our final portion of the webinar, I want to take this time to go ahead and answer some of the questions that you guys have been asking throughout. So I'll go ahead and start with a few. I'm going to try to get to as many as I can in the amount of time we have left. So Mike, you remember the question? No. So my first question for you that I got is, how do you foresee these laws evolving or expanding in the future?
So in terms of this law expanding, or kind of what's our direction, well, the current kind of privacy landscape that we see is California is definitely the pioneer, and I would consider California almost the privacy policy laboratory for Congress in some sense, because California is usually the first to create a big law like it has, which was in fact the case in the states. However, subsequent to the CCPA, we've seen a patchwork of regulations pop up around the states that are similar to the CCPA, similar to the GDPR, which has created effectively a regulatory minefield throughout the United States. And the big concern for companies is, well, if data is flowing across, kind of this, borderless, no state line internet network, well, how do we comply with regulations going from state to state? It's a good question. And so part of the challenge currently is you need to assess your risk with different state laws and where your data is traveling, which goes back to, it's very important that you understand your data flows, where it's moving, why it's going to there, does it have to be really traveling there, to really lower our risk in this situation. But with all that, Congress is definitely under the gun in terms of looking at enacting a national legislation in order to put a more comprehensive privacy framework across the United States. So privacy professionals and corporations are, I would say retail and marketing companies are screaming to Congress, trying to lobby their efforts in to get some of the benefits that they want. But I would say the hope is that Congress is able to kind of pick and pull the different good things about the regulations across the states from the CCPA, the good parts of the GDPR, and to make a nice baseline regulation. But Congress didn't pass one in the last legislative setting, and I wouldn't expect it to be, right out the gates either early next year. So I wouldn't sit back and think, well, I'm going to wait to comply with the national one, because I will say this: it's fairly certain that when Congress does pass a regulation, the characteristics, there's going to be a lot of similarities in terms of what California is already doing, how GDPR is already going in that direction. You want to have to start creating an operational setting similar to these major privacy laws that are in place in the world currently, because the reality is your company needs to get to that at some point.
Great question. Okay, moving on to the next one. I'd like to know what California government entity will enforce, monitor, or manage this compliance, and if it's adopted beyond California, what United States entity will most likely be tasked with this role?
All right, so good question. So the CCPA, the enforcement of the CCPA, I would say we need to kind of bifurcate this and look at it in two frames. One of the frames being that the California Attorney General he's going to kind of be the lead enforcer on this regulation, as we briefly discussed earlier. And so in terms of government entity in California, it's the California Attorney General that's going to be he's going to be the sheriff for the CCPA and will be enforcing it upon entities. And once he releases the final regulations, or it's 6 months after, it's game time for the California Attorney General. So it can be, if he wants to release on January 1st and say this is final, then that's it. But let's not forget that in addition to the government, private individuals and consumers can bring claims starting January 1st, regardless when the Attorney General releases his final version. So enforcement actions are, starting up from January 1st, whether an organization gets hit by a private plaintiff, which could turn into a class action, or gets hit up by the Attorney General. So it's subject to a little bit of timing issues there, but the Attorney General is going to be the responsible government entity there. And now, in terms of the latter parts of the question, if this expands the rest of the United States, well, so this regulation doesn't matter where you are in the world is in terms of being where your company is physically located. For example, if you're a company in Europe and you're doing business with California, you're subject to the law, just as any other business, whether in California, New York, etc. Now, the question people then go, well, how are they going to take me into court? Well, they have different ways. And like I'll use the GDPR as an example. Within the GDPR, there's a provision that Europe tries to create cooperative agreements with the U.S. to be able to enforce each other's laws. And so there is cooperative agreements along with local authorities. But in addition, what these regulators can do, they can publicly post different sites and companies to their boards, and so you got to be careful about the goodwill of your company if you get put on these lists, because there's lists of companies that are fined and not in compliance. And in today's in the data age, I would say it's extremely important in terms of not only marketing but for your consumers that they have trust and that you guys are protecting the data and that you have that goodwill and that you aren't going to run the path of having to worry about the supervisory authorities and the regulators here in California.
Okay. Next question. How will they find out if I'm compliant or not? And will there be regular audits, or does enforcement happen when a California resident sues?
Okay. So a couple parts to that question. I think in terms of one easy way to find out is you get a letter at your office and your agent, whoever's accepting that, is saying, hey, we're getting sued. Or we're getting a complaint from a consumer saying, hey, you are not using my information how you're supposed to use it, and we're going to take action. Now, but with the CCPA, the good news is for your business is, as it stands, you have a 30-day cure period. And so you can take steps to fix whatever that issue is. And so the consumer can be the one to put you on notice, though. And now you need to take compliance measures into your own hands and make sure that 30-day window is not a lot of time to isolate what the cause of the breach is, what in fact is actually wrong, and to get to the source of that. So that kind of makes me go back to it's critical that your company has incident response policies within to understand what you do in a situation like that, and further to have teams engaged internally to be able to respond accordingly in a speed, because those incident responses are absolutely crucial in being able to mitigate the possible damages that your company can face if fines were to occur. And my last point on that is all those policies and internal efforts. When you document and you draft that your company's in fact taking those measures, that is something that in court, if wherever it gets to that point, that those factors are used in consideration of how heavy of fines that the system wants to place on your company. So it's important that you take these measures and at a minimum show that you're doing everything you can in order to reach compliance.
Okay, next question. How long does it usually take for a company to be ready for compliance?
So when I think about compliance, I think too often people think about compliance as a destination, and I don't think CCPA or GDPR is that. I think that these regulations need to be looked at as a journey that require an ongoing effort for compliance. So there is an initial phase in which that we got to bring a company into compliance, and there is no definitive answer in terms of whether it's 1 month or 5 years, depending on the size and scale of the company. But most companies want to spend that year up front and start preparing well in advance. And a good example is these regulations typically give a 1 or 2 year period in which pre-enforcement time in order to allow companies to get in compliance. And most companies say that's not enough time. And so that 1 to 2 year period is something companies struggle with. And PricewaterhouseCoopers released a research study not long ago, and I think it was 86% of executives said they just wish they had more time. So it's imminent.
Okay. We have time for maybe 1 or 2 more questions. Yep, let's see here. It looks like, does this apply to universities?
As a starting point to that question, we need to ask, is this university for-profit or not-for-profit? Because the CCPA applies to for-profit businesses. So if we're talking a non-profit business, I wouldn't even go as far as to say it doesn't apply. We have to be very careful. Even non-profit businesses interact with vendors and other entities in which are for-profit that could be handling students' information, different organizations within the universities. So the answer is yes, it does apply. But when we get to the nonprofit setting, it's a little bit more of a gray area, and you need to kind of take the magnifying glass there a little bit more and understand where your data is moving.
Okay. Well, it looks like we're coming up on our time here. I know there's a few more questions that were in the question box. So if you would like to get those answered, feel free to reach out to Mike personally. His email is listed on the screen as well as his phone number. If there's anything regarding data backup recovery or any questions regarding quorum, feel free to reach out to myself. My contact information is also on the screen. But I'd like to take this time to say thank you to Mike and thank you to everyone who joined this morning. Feel free to, like I said, feel free to get in contact with us. And once again, we appreciate you being here, and we hope you have a great rest of your week.
Yeah. And again, on behalf of me, thank you guys so much for tuning in and talking privacy, and we'd love to help you. So feel free to reach out, and we'd love to speak with you more and help out your company.
Alrighty, and just before we go, this recording will be available, and for those that are looking for the actual deck, feel free to reach out to me, and I'll go ahead and get that over to you. Thank you. Have a good one.